એચપી જે એસોસિએટ અકાઉન્ટ છે, જે ડિસ્પ્યુટેડ અકાઉન્ટ છે, એમાંથી સાહેબ એમના ખાતામાં જમા થયા હતા. એમનું સાહેબ નિવેદન ઇન્વેસ્ટિગેશન ઓફિસર દ્વારા લેવામાં આવેલું. એમાં એમને એવી હકીકત જાહેર કરી છે કે જે દુકાન છે એમની, એ દુકાન વિજય અપાર્ટમેન્ટ દેવભૂમિ ખાતેની, એ સાહેબ એ દુકાન છે એમ હર્ષિતજીને પોતાની ઓફિસ તરીકે ભાડે લીધેલી, અને એ ભાડાની જે રકમ છે એ રકમ આ છે. એમાંથી 1 લાખ રૂપિયા ડિપોઝિટ પેટે આપેલા હતા, એ પણ હર્ષિતજીને એમને આઈસીઆઈસી બેંકના ખાતામાંથી જમા આપેલા છે. એવું સાહેબ અત્યારે એમનું અવરમેન્ટ છે.
ભાડાનું ટ્રાન્ઝેક્શન છે.
હા સાહેબ, એટલે ભાડાનું ટ્રાન્ઝેક્શન છે સાહેબ. આમ બોનાફાઇડલી આઈ સ્ટેટેડ બિફોર ઓનરેબલ કોર્ટ કે એ જે ઓફિસ છે એ ઓફિસનો સાહેબ ગુનાના કામે કોઈ ઉપયોગ થયેલો નથી, એવું ઇન્વેસ્ટિગેશન દરમિયાન જણાઈ આવ્યું.
ઓફિસનો તો કદાચ થયો હોય તો ભાડે આરોપી રાખી છે.
હા, આરોપીએ રાખેલી છે, અને ભાડાના પૈસા સાહેબ જે અમાઉન્ટ દર્શાવેલી છે
એ બી રીઝનેબલ લાગે,
એ એમને ભાડા પેટે આપેલી છે.
કારણ કે એ અમાઉન્ટ કન્સિસ્ટન્ટ છે, 29,500 છે અને દર મહિનાની આવે છે.
હા સાહેબ, એટલે સ્ટેટમેન્ટ પણ આપેલ છે.
8,4,1,5,4,6,36,6 8, 9, 10 બરાબર છે. તો આનું કેમ ફ્રીજ કર્યું છે?
તપાસના કામે જે તે વખતે મળી આવ્યું હતું ત્યારે આવી રીતના જે ખબર નથી ને સાહેબ. તપાસના કામ પછી નિવેદન લીધું પછી આપણને ખબર પડી કે.
તો હવે ડિફ્રીજ કરી નાખો તમે. પેલા અગાઉ કર્યો.
જી સર.
જી સર. તમે જ ઇન્સ્ટ્રક્ટ કરી દેશો ને બેંકને હવે સ્ટેટ મોનિટરિંગ.
સર તો કરી પછી રિપોર્ટ કરી દઈએ, કરીને આપણે રિપોર્ટ કરી દઈશું.
કરીને રિપોર્ટ કરી દો ને કે ભાઈ આ હવે કઈ જરૂર નથી, કારણ કે અમે બી કાલે રાખું તો ખાલી રિપોર્ટ આજે કરી દેશો તો
કરી દઈએ સર.
આજે કરીને રેકોર્ડ ઉપર આપી દો આપતી સર.
પ્લીઝ.
Proceeds of crime has been identified and attached in this case. બીજા કોઈ આરોપી આવી ગયા?
યસ યસ.
Section 24 માં સાહેબ આપણે જોઈએ તો there are two parts, sir. A and B. A in any proceeding relating to proceeds of crime under this act, in the case of a person charged with the offence of money laundering under section 3, the authority of the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. Yama sir, word has been used, share, means that is a legal provision, legal presumption. And Bima sahib એવું છે કે in the case of any other person, the authority or court may presume. એટલે other than the accused ના સામેનું જો presumption draw કરી પણ શકે, ના કરી શકે, that depends on the facts of the case. એ પોઈન્ટ ઉપર સાહેબ સુપ્રીમ કોર્ટે મદનલાલના વિજય મદનલાલના કેસમાં સાહેબ સેક્શન 24 ઉપર સાહેબ ટોટલ એનાલિસિસ કરી અને એમાં સાહેબ પેરેગ્રાફ નંબર 327
ટોટલ એનાલિસિસ કરીને
સેક્શન 24 નું એનાલિસિસ કરી અને એના ઉપર
કયો પેરેગ્રાફ?
હું આમ પેરેગ્રાફ નંબર 327 to 351 છે, પણ relevant paragraph which I am going to point out before the honorable court is paragraph number 334, sir.
Hmm.
Be that as it may, this section deals with two situations. The first part concerns the person charged with the offense of money laundering under Section 3. The second part, Clause B, concerns any other person. Taking the second part first, such other person would obviously mean a person not charged with the offense of money laundering under Section 3 of 2000 Act. The two parts in one sense mutually exclusive if the person is charged with the offense of money laundering under Section 3 of the 202 Act owing to a complaint filed by the authority authorized before the special court. Clause A would trigger as regards the second category. Clause B, a person the expression used may presume. Whereas for the first category, covered clause A, the expression used shall, unless the contrary is proved, presumed. In this category, if charge is already framed against the person for having committed offense of money laundering, it would be presumed that the court framing the charge against him was prima facie convinced that the material placed before it has disclosed grave suspicion against such person. In such a case, once the issue of admissibility of the material supporting the factum of grave suspicion about the involvement of the person of the commission of the crime under the 2000 Act is accepted in law, the burden must shift on the person concerned to dispel their suspicion. It would then not be a case of reversal of burden of proof, as such, but one of the shifting of burden on him to show that no offense of money laundering has been committed, and in any case, the property procedure of crime was not involved in money laundering. Our આ કેસની અંદર સાહેબ, the complaint which has been filed and charges were framed by the honorable court. The charges leveled against the accused have been prima facie found by this honorable court that this money laundering has been taken place, sir. And in that money laundering amount is the amount which was actually received to his wife and transferred to other properties, and the property which was forwarded out of India, sir. Both the properties have been considered, sir. And the evidence which has been brought on record is the same evidence which is in the complaint and documents which has been filed before the honorable court, sir. Amma, sir. સુપ્રીમ કોર્ટનો સાહેબ જે ડિસ્ચાર્જનો ઓર્ડર છે એ આપો સાહેબ. એમાં સુપ્રીમ કોર્ટે પણ પ્રાઇમા ફેસી હોલ્ડ કર્યું છે. એમાં પેરેગ્રાફ નંબર 8 સર, સેકન્ડ પેજ ઉપર. That is the observation of this honorable court, sir. સુપ્રીમ કોર્ટે આ કોર્ટનો સાહેબ જે ઓર્ડર હતો which was challenged before the honorable high court, and the gist of that order has been actually reproduced, sir. Para 8 ma. Observe that from the material on record and on the basis of investigation by respondent one, it prima facie appears that the appellant is involved in hawala, that is illegal transfer of money to foreign countries. He also appeared to be the possession of proceeds of crime, and prima facie appears to be involved in offense like to affect the economy of the country. It was further held that it appears from the material on record that the appellant is prima facie involved in hawala transaction of crores of rupees as well. Further, in the trial court opinion, the appellant had miserably failed to discharge the burden of proof under Section 24 of the PMLA which had shifted upon him to show that proceeds of crime are untainted property. Such prima facie material sufficient to infer the appellant's involvement in such a serious case did not warrant interference in the opinion of special judge, and therefore the trial court refused to discharge the appeal, thereby rejecting the application of section 2. પછી હાઈકોર્ટનો સાહેબ ઓર્ડર છે એમાં પણ સેમ વસ્તુ છે. હાઈકોર્ટે ઓલ્સો રિજેક્ટ અને સુપ્રીમ કોર્ટે સાહેબ જે રિજેક્શન કર્યું એમાં પેરા 23 સાહેબ એમાં વિજય મદનલાલનો પેરેગ્રાફ નંબર 34 સર રિપ્રોડ્યુસ થયો છે 134 સર પેરા 23 અને એમાં ધ process or activity can be in any form, be it one in concealment, possession, acquisition, use of procedure crime as such, the projecting it as untainted property or claiming it to be so. Thus, involvement in any one of such process or activity connected with the proceeds of crime would constitute the offence of money laundering. This offence otherwise has nothing to do with the criminal activity relating to the scheduled offence, except the procedure of crime derived or obtained as a result of crime. પછી next page ઉપર સાહેબ એમાઉન્ટની વાત છે સાહેબ પેરા 26 સર. Another ground urged by the appellant is that the amount involved does not meet the statutory threshold for initiating proceeding under the PMLA as it stood prior to the amendment. The appellant has relied upon the monetary threshold of 30 lakhs to argue that at the relevant time, the offence did not attract the provision of PMLA. This argument is equally devoid of merit. The respondent has placed substantial material on record to demonstrate that the quantum of procedural crime significantly exceeds the statutory threshold. The financial trail indicates that the aggregate value of the assets derived from the alleged criminal activity is well beyond the prescribed limit. It is settled law that the determination of the threshold value must be based on the entirety of the transaction and not an isolated instance or a narrow interpretation of specific amount at any given time. Next, the respondent has categorically established that the amount in question far exceeds the threshold of rupees 30 lakhs, even under the unamended provision of PMLA. The allegations against the appellant involve alleged land allotment transaction facilitated through forgery, cheating, and fraud, resulting in an illegal loss of 1 crore to the government, along with hawala transaction of crores of rupees and illegal gratification through his wife of around 22 lakhs. The financial transaction in the alleged act as evidence from the record reveal a considerably higher amount of the proceeds of crime, rendering the appellant reliance on the threshold limit baseless. Furthermore, it is settled law that the determination of the amount involved in a money laundering offence is not to be viewed in isolation, but in context of the overall financial trail and associated transaction. The totality of evidence must be assessed with a matter of trial, but even on a prima facie assessment, it is clear that the procedural crime in the present case are significantly higher than the statutory threshold. The applicant has failed to substantiate his claim with any material that contradict the respondent's submission in this regard. Therefore, this ground also does not aid appellants in any manner. Hello, sir. Supreme Court has also held, sir, on the same evidence which has brought on record, sir, that the threshold of 30 lakh rupees is more than 30 lakh rupees money has been actually actually, procedure of time has been generated and layers. It is this is the loss. In these circumstances, the Exhibit 123, sir, which is the Bank of America statement, which has been brought on record, sir. It consists several entries, and all the entries are indicating the transfer of money from India to his wife's account. And through some of the entries have been transferred through Hawala and utilized by the accused in his name, sir. His clarification is that I was in the jail. My debit card must have been utilized by somebody else. That is who has used, how it has not come on record. That was a prima facie. The offense was, and after recording of the evidences, conclusive evidence is there, sir, to establish the guilt of the accused. Now coming to the aspect of sanctions. The sanction by the competent authority has been brought on record by the evidence of Ashok Dave, who is authorized to sign the sanction order for the government as per the office rules. Two things, sir, may arise, sir, that the sanction, when the complaint was filed, there was no sanction under Section 197 subclause 1. That is a fact, and admitted fact. Subsequently, the Honorable Supreme Court by verdict observed that 197 is necessary for Section 197 for the PMLA Act, sir. That's why, as early as possible, the department moved to the competent authority, Government of Gujarat, and Government of Gujarat has accorded the sanction, and sanction has been brought on that person. The Honorable, there are two judgments of the Supreme Court, sir. In one judgment, sir, it has been held that the sanction, without sanction, if the cognizance is taken, then it does not vitiate the trial, first thing, sir. Second judgment is to the effect that sanction can be brought on record during the course of trial also. These two aspects, sir. And thirdly, sir, 197, when applicable, sir, when the public servant has committed the offense during the course of his employment or in the guise of his or color of his official duty. Here, sir, procedure of time is a separate offense. In this case, the opening of the making a partner to his wife, that is not his official function, sir. And actually diverting the money, collecting the money to the person who was benefited. And secondly, this was also not his official duty to transfer the money to USS. That's why, otherwise also, sir, 197 is not applicable to the facts of the case. But actually, just to err on the safe side and for the prudence, the sanction has been In these circumstances, also the sanction has been accorded by the government of Gujarat, sir. That's where the act is maybe conducted. I will submit my return submissions.
I could not get your last point.
મારો લાસ્ટ પોઈન્ટ એવો છે સાહેબ
The
કે
sanction was not necessary in the given set of facts.
કારણ કે એમના વાઇફને પાર્ટનર બનાયા વેલ્સપનમાં. That was not his official function. Secondly, એના વાઇફના એકાઉન્ટમાં જે પૈસા ટ્રાન્સફર થયા એ અને એના વાઇફમાંથી જે પૈસા ટ્રાન્સફર એકાઉન્ટમાં ટ્રાન્સફર થયા અને એમને વિડ્રો કર્યા, that is after his official function was over. Subsequent to the generation of procedure of crime is subsequent to his official functions, not during the course of his official function.
Which official function?
Official function to pass the order of land allotment. And that is after that, sir. All this act has been committed after the schedule offense was committed, sir. I thought just no, this is pointing out to the honorable court, sir.
See, when you make your argument on one side, you should also look whether by arguing the second point, your entire case do not get extinguished. So far as when you make a submission, it was the first official act was with pertaining to
Land.
allotment of land. So the moment you say it is official act,
For that, because while discharging his official duty, he has committed that offense. But
now you are saying that while committing official duty, he has committed some offense.
yes,
And then you want to bifurcate. The first
proceed of
party
crime, sir.
official
એટલે
duty,
આ સુપ્રીમ કોર્ટનો ત્યાં સુધી છે કે the schedule offense might have been committed and the procedure of crime may be generated subsequent.
there is no dispute to that proposition.
Yes, sir.
The schedule offense is committed, procedure of crime might be generated subsequently. Or it might have come into knowledge subsequently.
Yes, sir.
That is not a dispute. But the dispute which in this case you are arguing, okay, first, since that act was under official act, therefore section 197 would not apply.
નહીં, એમાં તો apply, એમાં sanction હતી, એમાં he has been convicted.
No, no, it's convicted.
હા,
But you are saying that it was his official duty.
in the function during the course of his employment as a public servant, he has committed the schedule offense.
So that would require his sanction.
Yes. But so far as section 3 and 4 is concerned, that is actually confined to the now, yeah, there is also sanction is there, sir. Sanction has been proved properly.
See, you,
Emma, sir, original sanction is that activity.
if you are saying that the first act was official duty, then section 197 would be mandatorily required. There cannot be doubt because
Yes.
it was his official duty. Now you want to bifurcate. Here, first official duty, he committed that offense. But the proceed of crime has traveled subsequently, which is not part of his official duty.
Yes, sir.
So it goes without saying, suppose a person accepts a bribe, he does some act favoring in passing some order, and then he gets that money after 1 month, 2 months, 3 months, we don't know, in whatever manner. Then it would be part of that offense only.
Yes. The schedule
No,
offense is that is the first condition.
You can't bifurcate, can I by, this is
Ele-
not part of act.
Yes. એટલે
It is
સુપ્રીમ કોર્ટે
official duty.
yes,
but
yes,
this is
second,
now separate.
yes, I
Because
follow, sir.
It
I
is-
follow the
That proceed of crime.
First
has
of all,
been
schedule
generated
offense is
from
to be
that
established.
offense only.
Yeah.
So you can't
It-
bifurcate for saving yourself from
yes,
197.
sir. Procedure of crime follows schedule offense. Unless the schedule offense is committed, procedure of crime cannot be
So far
generated.
as 197 only I am
That
saying.
is precondition.
197 only I am saying. You can't bifurcate, કે ભાઈ,
Yes, sir.
the act is
No,
done,
yeah, I follow the actually.
then POC came
Yeah.
subsequently, therefore POC receiving, sending, that would be a separate. Therefore no sanction 197 would be required.
એટલે જ પેલું વિભુ અને આચાર્યનું જજમેન્ટ એટલા માટે સુપ્રીમ કોર્ટે આપે છે.
Anyway, yes.
હા, this is that.
So now your written argument,
હું સોમવાર મંગળવાર આપીશ.
Somvar,
હા,
without fail.
yeah, right.
So now your everything is over,
I have
except filing written argument.
written service.
ચાલો. તમે સોમવારે એમની આર્ગ્યુમેન્ટ લઈ લ્યો.